My name is Jonathan Adler. I'm a professor here at the law school, and it's my honor and pleasure to welcome all of you to this year's Sumner Canary Lecture. As some of you know, the Sumner Canary Lecture is perhaps the law school's premier endowed lectureship that we've hosted now for several decades and has included lectures by the late Justice Antonin Scalia, Judge Frank Easterbrook, and the subject of today's lecture, Justice Neil Gorsuch. It was established to honor the memory of the late Judge Sumner Canary, who was a judge on the Ohio Court of Appeals for the 8th District, as well as U.S. Attorney for the Northern District of Ohio, and was also a partner first at Canary and Walsh and later at Arter and Haddon. And the law school certainly appreciates the generosity of Judge Canary's widow, Nancy, who made this lecture possible. Today, it's really my distinct pleasure to be able to introduce this year's lecturer, the Honorable Diane Sykes of the U.S. Court of Appeals for the 7th Circuit. She is a graduate of Northwestern University and Marquette University Law School, worked as a journalist, worked as an attorney in private practice, spent about 7 years as a Milwaukee County Circuit Court judge before joining the Wisconsin Supreme Court in 1999. And then in 2004, she was confirmed to the U.S. Court of Appeals for the 7th Circuit. I learned today that she has written, she may not even know this, approximately 700 majority opinions in her time on the U.S. Court of Appeals for the 7th Circuit, and then a decent number of concurrences and dissents in quite a few notable cases, and I think is widely recognized as one of the premier federal appellate judges, and it's certainly our honor to have her here today to lecture on what we've learned thus far about the jurisprudence of Justice Neil Gorsuch. You didn't come here to listen to me, so without any further ado, I will turn it over to Judge Sykes.
Thank you, Jonathan, and thanks to all of you for coming out on this snowy afternoon. I know that's not daunting for all of you, as it's not daunting for me coming from Wisconsin, but I do appreciate your attendance here this afternoon. Thanks for the invitation to deliver this year's Canary Lecture, and it's a great honor for me to participate in this lecture series, and I'm just delighted to be with you today. As we come together this afternoon, the clock is ticking down on the Supreme Court term that began last October. OT 2017 will likely be one of the most significant and closely scrutinized court terms in recent memory. Only 4 weeks of argument remain, just 12 days spread across 2 weeks this month and 2 weeks next month. It has not escaped notice that the justices have not issued very many merits opinions so far this term. We've had a few in the last few weeks, but all of the big cases this term are still undecided. That will make for a dramatic finish, as Professor Adler and other legal commentators have noted. Of course, almost everything the court does is important, and each term produces at least a few blockbuster opinions. But law professors and pundits agree that this term will be particularly consequential. Last fall, Justice Ginsburg confirmed the point in a notable interview just before the term started. She said that there is only one entirely safe prediction that could be made about the upcoming term. She said it will be momentous. The reason, of course, is that we have a new justice. And there's an old saying that a new justice means a new court. There's truth in that observation, as I know from my own experience serving on the Supreme Court of my home state of Wisconsin. Courts are human institutions. Interpreting and applying legal texts requires judgment, and judges differ in the priority and weight they give to various sources of law, rules of legal interpretation, and normative constraints on their judgment. With that in mind, I'd like to focus today on what, by any measure, was the biggest law story of this past year: the confirmation of Neil Gorsuch as Associate Justice of the Supreme Court, filling the vacancy created by the untimely death of Justice Antonin Scalia. I think we can all agree that our newest justice has very big shoes to fill. Justice Scalia's influence on our law can scarcely be overstated. He was one of the most consequential justices in our history. More than any other figure, he was responsible for the two most important movements in interpretive method in our time. He reestablished the primacy of textualism in statutory interpretation, and he revived originalism in constitutional interpretation. These ideas have their own force and have always been with us. But Justice Scalia's explanation of the justification for these overlapping interpretive theories was powerful and persuasive, and has been uniquely responsible for their restoration. It's not too much to say that he changed the terms of the debate about the role of the judicial branch and the practice of judging in our republic. Justice Scalia's sudden death in February of 2016 was an enormous loss to the court. The 13-month interregnum before his successor took his seat turned out to be a low-key, no-drama period of quietude as the Chief Justice steered his short-handed court away from high-stakes controversies, and the justices waited for a new colleague. Professor Will Bode, a law professor at the University of Chicago, referred to this period as the calm before the storm. Astute court watchers agreed, and here again a nod to your own Professor Adler. Time will tell whether they're right, but I wouldn't bet against them. So, we gather here today at the dawn of a new court, and I think it's fitting to turn our attention to our newest justice. No doubt everyone in this room followed his nomination and confirmation with great interest. Judge Gorsuch's elevation was noteworthy for many reasons, not the least of which is that it's been a long time since we've had a justice from the Mountain West flyover country. Many commentators have pointed out that Justice Gorsuch brings some welcome geographic diversity to a court long dominated by Easterners. In that respect, he follows in the distinguished footsteps of his first boss and mentor, Justice Byron White. I'll come back to this point about geographic diversity at the end of my remarks today. Now, I'm sure it will come as no surprise to hear that I have long admired Judge Gorsuch's work from my vantage point 2 circuits away, as the crow flies, not numerically. He is a very worthy successor to Justice Scalia. He appears to have many of the same judicial attributes and jurisprudential commitments as his predecessor, but there are important differences as well. My goal today is modest. I will not make any predictions about how Justice Gorsuch might vote in particular cases, or even, more generally, in particular classes of cases. That's a hazardous undertaking for even the most experienced scholars of the court, but it's entirely off-limits for a lower court judge. Instead, I thought it might be useful to review the decisions that Justice Gorsuch wrote in his first few months on the court at the very end of last term, and look for some broader insights into his approach to his new role. The first thing to notice is how many decisions he wrote. He was confirmed in time for the final round of arguments in the term, 13 cases heard across 2 weeks in April, and was assigned to write for the court in just 1. But he wrote 7 separate opinions, 3 dissents, 3 concurrences, and a formal statement in the Justice Thomas tradition urging the court to grant cert on a particular legal issue at its next opportunity. That was a remarkable debut for a new justice. This rapid pace of separate opinion writing so early in a new justice's tenure is unprecedented. Perhaps we should have seen it coming in his energetic participation at oral argument. In recent years, only Justice Sotomayor jumped into the fray so quickly as an interlocutor from the bench. A more gradual approach seems to be the norm. There was no shortage of media commentary about our new justice's confident and energetic performance early on in his tenure. Richard Wolff of USA Today wrote that Justice Gorsuch arrived in April with gusto. Adam Liptak, the Supreme Court reporter for the New York Times, described Justice Gorsuch's first opinions as remarkably self-assured for a brand new member of the court, thus demonstrating his readiness to swing for the fences. Robert Barnes of the Washington Post made similar observations, noting that in his short 2.5 months on the Supreme Court, Gorsuch has proved himself to be a self-assured jurist, unafraid of the big stage. NPR's Nina Totenberg, another veteran of the Supreme Court press corps, pronounced that Justice Gorsuch seems both sure-footed and sure of himself and his views. Linda Greenhouse, who used to cover the court for the Times and now writes a column for the paper, was harshly critical of Justice Gorsuch's assertive performance so soon after joining the court. She devoted a full column to what she called the sheer flamboyance of the junior justice's behavior. Northwestern law professor John McGinnis entered the discussion with an interesting post in response to some of this early commentary. In his view, Justice Gorsuch's confident performance flows directly from his formal conception of law. Being a Supreme Court justice for a formalist is no different from being any other kind of judge, and in particular, no different from being the Court of Appeals judge Justice Gorsuch had been for over 10 years. Under this view, the lawful judge should render judgment on the basis of his best judgment about the meaning of statutory and constitutional provisions that are put before him or her, and candidly set out the reasoning in support, regardless of the political consequences and regardless of what others think. Thus, as a formalist and experienced judge, Justice Gorsuch was able to act forcefully from day one on the Supreme Court. That struck me as a very insightful point, and I think we'd do well to keep it in mind as we examine Justice Gorsuch's early work. So let's turn to that now. This will not be a comprehensive analysis of his first set of opinions. I'll limit my comments to those that I view as most worthy of our study. His first opinion for the full court, his first two merits dissents, and his first two merits concurrences. From these opinions, I offer three very general takeaways. First, Neil Gorsuch is a textualist, and the Pope is Catholic. If anyone thought he would turn out to be anything other than a principled textualist like his predecessor, these first few opinions put that misconception to rest. With that observation out of the way, my second point is this. Neil Gorsuch writes in forceful, vivid prose and with incisive clarity, just as his predecessor did. But his style is more informal and sometimes downright conversational. He directly engages the reader with plain language and effective use of simple rhetorical questions to bring an otherwise complex dispute into sharper focus. Clear and lively writing is valuable for its own sake, but it can also be a powerful tool of persuasion and produce a more accessible set of instructions for the bench and bar and for the other branches of government. There's something else to notice about his writing style. When he disagrees with his colleagues, he is unfailingly respectful and polite. This, too, distinguishes him from his predecessor. Justice Scalia's separate opinions were always powerful and always eloquent, but I think we can agree that they were sometimes also sharp-edged. My last takeaway is a more substantive point. Justice Gorsuch is deeply committed to enforcing the boundaries of the structural separation of powers, including the limits on the judicial branch within that structure, while at the same time maintaining a strong and independent space for the judiciary within our system of government. He also seems to hold process values in high regard. All of these attributes and jurisprudential commitments were on display in Henson versus Santander Consumer USA, Justice Gorsuch's debut opinion for the full court. The case raised a routine statutory interpretation question, albeit one that had divided the lower courts. Whether debt buyers qualify as debt collectors under the Fair Debt Collection Practices Act. In keeping with recent tradition for new justices, the court's decision was unanimous, and the case was entirely pedestrian. Some would say boring. Justice Gorsuch's opinion for the court was not boring. Here's the background. The statute in question provides a remedy for abusive practices by debt collectors. It defines debt collector as anyone who regularly collects or attempts to collect debts owed or due another. The act dates to 1977, and since then the debt buying business came into being and mushroomed. The circuits were split on whether debt buyers were covered. The Henson plaintiff sued a company that purchased default auto loans and then collected them on its own account. Here is how Justice Gorsuch began his opinion for the court. Disruptive dinner-time calls, downright deceit, and more besides drew Congress's eye to the debt collection industry. From that scrutiny emerged the Fair Debt Collection Practices Act, a statute that authorizes private lawsuits and weighty fines designed to deter wayward collection practices. So perhaps it comes as little surprise that we now face a question about who exactly qualifies as a debt collector, subject to the Act's rigors. Everyone agrees that the term embraces the repo man, someone hired by a creditor to collect an outstanding debt. But what if you purchase a debt and then try to collect it for yourself? Does that make you a debt collector too? That's the nub of the dispute now before us. Much ink has been spilled about this colorful opening with its alliteration and informality, the repo man, the nub of the dispute. Less noticed is the conversational use of the second person, as if the writer was speaking directly to the reader. What if you purchase a debt and then try to collect it for yourself? Does that make you a debt collector too? Justice Kagan often uses this technique, and to a lesser extent so does the Chief Justice. They are both very gifted writers, and their opinions are justly praised for their clarity and rhetorical punch. Justice Gorsuch uses this technique no fewer than 14 times in this debut opinion. Here's one more example that I found particularly effective. Recall that the term debt collector means anyone who regularly collects debts owed or due another. The plaintiffs pointed out that the term owed is the past participle of the verb to owe. They knew that a textualist judge will sometimes consult ordinary rules of grammar to help solve interpretive puzzles. Invoking that principle, they argued that the statute must capture anyone who seeks to collect debts previously owed another. The grammatical premise is correct, but it's incomplete. Justice Gorsuch helpfully explained that past participles are routinely used as adjectives to describe the present state of a thing. So, for example, burnt toast is inedible, a fallen branch blocks the path, and equally, a debt owed to a current owner may be collected by him or her. To drive the point home, Justice Gorsuch again reverted to the conversational second-person style of address. Just imagine if you told a friend that you were seeking to collect a debt owed to Steve. Doesn't it seem likely your friend would understand you as speaking about a debt that is currently owed to Steve, not a debt Steve used to own and that's now actually yours? This informal style of writing makes the court's decision easier to grasp, but it's also doing important interpretive work here. Justice Gorsuch is using an ordinary, everyman style of writing to show us the ordinary, everyday meaning of the statutory text. By now, you've probably guessed how the court resolved the case, but I will keep you in suspense no longer. The term debt collector does not include a debt buyer collecting a debt for itself. Of course, there's much more to this statute and to the court's opinion than just the few short passages I've shared here. And this brings me to another important point about Justice Gorsuch's likely influence as an opinion writer. Many commentators have highlighted the easy, breezy style of his Henson opinion, but its real strength actually lies in its structure. Justice Gorsuch organizes his opinion as a conversation with the loser. Rather than start with a long, impenetrable account of the entire statutory regime, he lays out just the key portion of the text and identifies its most natural and straightforward reading. Moving on, he introduces other relevant parts of the statute gradually as he sets up and tears down the loser's arguments. It's almost like a game of tennis. Each of the loser's arguments is carefully served up in its own paragraph, only to be volleyed back and forth until the opinion's point is scored in the next paragraph. The arguments become more specific, more nuanced, and more difficult as he moves along, as if to guide the reader from the shallow to the deep end of the pool. Forgive the mixed sports metaphors here. He then wraps up, like any good textualist, by dismissing the last-ditch policy arguments. Why is this so much more persuasive and easier to read than most judicial opinions? Because it's written the way people actually think. No one can hold an entire statute in his head and evaluate a barrage of legal arguments introduced later on. We tend to think in points and counterpoints. Statutes are dense and tedious things. There's a substantive command at the core, but usually many exceptions, and exceptions to the exceptions, and interlocking definitions and cross-references. Proceeding in small steps through the relevant text makes it easier to understand what the law is and why particular parts of the law may or may not be decisive in the case. Justice Gorsuch gives us each piece of the law as needed to understand each piece of the argument. How sensible is that? My final takeaway from this first Gorsuch opinion for the court is this. Our newest justice is not content to simply say what the law is, dispatch the loser's arguments, and then call it a day. He closes his opinion in Henson with an elegant structure of government point, situating his textualist methodology within our constitutional system of separated powers. Here's what he wrote. While it is, of course, our job to faithfully apply the law Congress has written, it is never our job to rewrite a constitutionally valid statutory text under the banner of speculation about what Congress might have done had it faced the question that, on everyone's account, it never faced. Reasonable people can disagree with how Congress balanced the various social costs and benefits in this area, and the evolution of the debt collection business might invite reasonable disagreements on whether Congress should re-enter the field and alter the judgments it made in the past. After all, it's hardly unknown for new business models to emerge in response to regulation, and for regulation in turn to address new business models. Constant competition between constable and quarry, regulator and regulated, can come as no surprise in our changing world. But neither should the proper role of the judiciary in that process, to apply, not amend, the work of the people's representatives. Let's move now to Justice Gorsuch's first dissent and first concurrence. And here I'll ask you to recall Professor McGinnis's point about judicial formalists. Our new justice's first dissent came in Perry versus Merit System Protection Board, a highly technical case about the proper forum for judicial review of certain decisions of the MSPB, an administrative tribunal that resolves workplace disputes by federal civil service employees. A highly complex statutory scheme sets up a bifurcated system of judicial review. Civil service claims go to the Federal Circuit in Washington, D.C., and get deferential review. Discrimination claims go to the Regional District Court and get de novo review. The statute is so dense that Justice Alito asked at oral argument, who wrote this statute? Somebody who takes pleasure out of pulling the wings off of flies? Justice Ginsburg's opinion for the court holds, and I'm radically simplifying here, that certain mixed cases, those raising both civil service and discrimination claims, go to the district court for review, though that's not actually what the statute says. This atextual reading, she said, was a sensible way to resolve inefficiencies associated with the bifurcated review system actually set forth in the statute. Unsurprisingly, Justice Gorsuch objected on textualist grounds. He wrote that if a statute needs repair, there's a constitutionally prescribed way to do it. It's called legislation. The business of enacting statutory fixes, he continued, belongs to Congress and not this court. He goes on to explain why fidelity to the statutory text, also known as formalism, really matters. Here's what he wrote. Taking up Mr. Perry's invitation to tweak the statute also seems sure to spell trouble. Look no further than the lower court decisions that have already ventured where Mr. Perry says we should follow. For every statutory fix they have offered, more problems have emerged, problems that have led only to more fixes still. New challenges come up just as fast as the old ones can be gavelled down. Respectfully, I would decline Mr. Perry's invitation and would instead just follow the words of the statute as written. Even in this obscure and esoteric case, our new justice shows himself to be a principled and thoroughgoing textualist. Justice Gorsuch's first concurrence was all about process values. The case was Maslin-Jack versus United States. It raised an interpretive question about an immigration statute that makes it a crime to secure naturalization contrary to law. When the case at hand involves an immigrant's own naturalization, the government has to prove that the immigrant committed some illegal act in connection with his naturalization proceeding. The question before the court was one of causation. Must the government prove that the unlawful act actually contributed to the naturalization decision? The unanimous answer of the court was yes, and Justice Kagan's opinion for the court explained why the statutory language required that result. But she did not stop there. She went on to craft a two-part test for proving causation, with several subparts, and also an affirmative defense. Justice Gorsuch took issue with these causation tests and the affirmative defense, none of which had been briefed by the parties or addressed by the lower courts. His objection was modestly stated. He wrote that the work here is surely thoughtful and may prove entirely sound. But respectfully, he said, it seems to me at least reasonably possible that the crucible of adversarial testing on which we usually depend, along with the experience of our thoughtful colleagues on the district and circuit benches, could yield insights or reveal pitfalls we cannot muster guided by our own lights. He concluded this way: for my part, I believe it is work enough for the day to recognize that the statute requires some proof of causation, that the jury instructions here did not, and to allow the parties in the courts of appeals to take it from there as they usually do. This court often speaks most wisely when it speaks last. I've decided to call this the Matthew chapter 6, verse 34 concurrence. Let the day's own trouble be sufficient for the day. Clearly, Justice Gorsuch believes in adhering to the traditional norms of judicial process, but it's not process for its own sake. He deeply respects his former colleagues. He wants to hear and learn from their work, and he holds the adversarial process in high regard as a hedge against judicial error. These same commitments can be seen at work in another of Justice Gorsuch's opinions from the end of last term, his dissent in Pavin versus Smith. The case involved a challenge to the birth certificate regime in the state of Arkansas in the wake of Obergefell versus Hodges, the Supreme Court's same-sex marriage decision. Two female same-sex married couples filed suit to alter Arkansas's rules for listing a child's parents on a birth certificate in order to accommodate the new reality of married same-sex parents. Each couple had conceived and born a child through anonymous artificial insemination. In each case, the State Department of Health issued a birth certificate listing only the birth mother's name. That was consistent with state law, which provided that the birth mother, of course, is always listed. If she is married, state law further provides that her husband shall be entered on the birth certificate as the father of the child. An exception exists if the birth mother and her husband file affidavits identifying someone else as the child's biological father, and the other man files an affidavit acknowledging paternity. A separate statute covers children conceived through artificial insemination. It provides that any child born to a married woman by means of artificial insemination shall be deemed the legitimate natural child of the woman and the woman's husband if the husband consents in writing to the artificial insemination. As the Arkansas Supreme Court read this statutory scheme, the requirements for listing a child's parents on a birth certificate centered on the relationship of the biological mother and the biological father to the child, not on the marital relationship of husband and wife. On this understanding, the state high court held that the birth registration regime was not inconsistent with Obergefell. The Supreme Court summarily reversed, rejecting the state court's determination that Arkansas had established a birth recording system premised on biological parentage. In a brief per curiam opinion, the court noted that the statutory provision pertaining to artificial insemination showed that Arkansas had chosen to make its birth certificates more than a mere marker of biological relationships. The state uses those certificates to give married parents a form of legal recognition that is not available to unmarried parents. And having made that choice, the court said, Arkansas may not, consistent with Obergefell, deny married same-sex couples that same recognition. Justice Gorsuch dissented, joined by Justices Thomas and Alito, but he did not announce his judgment on the merits. Instead, he objected to the court's unusual choice to proceed directly to decision without full briefing and oral argument. Summary reversal, he said, is strong medicine. It's usually reserved for cases where the law is settled and stable, the facts are not in dispute, and the decision below is clearly in error. Nothing in Obergefell had directly addressed the constitutionality of a birth registration system based on biological parentage. He noted that Arkansas's birth certificate regime has many analogs across the country, and the state Supreme Court did not in any way seek to defy Obergefell, but rather sought earnestly to engage the Supreme Court's decision. Whatever else we might do with this case, he concluded, summary reversal would not exactly seem the obvious course. He had other procedural objections too, but I think you get the gist. The issue in the case was substantial and unsettled. The state high court's decision was not an act of defiance. In the ordinary course, merits review at the court entails a full adversarial process before the court, with a complete round of briefs and oral argument. For Justice Gorsuch, due respect for a reasoned decision of the state judiciary on an open question of federal constitutional law warranted giving the case the normal plenary consideration, not a summary disposition. Finally, I'll say just a few words about Justice Gorsuch's concurrence in Trinity Lutheran, the court's important religious liberty case from last term. Trinity Lutheran Church operated a preschool and applied to participate in a Missouri program that awarded grants to nonprofit organizations that purchased playground surfaces made from recycled tires. Missouri denied the application simply because it came from a church. Trinity Lutheran argued that the state's policy of excluding churches from the playground resurfacing program violated the Free Exercise Clause. The Supreme Court agreed. In an opinion by Chief Justice Roberts, the court held that Missouri's policy expressly discriminates against otherwise eligible recipients by disqualifying them from a public benefit solely because of their religious character. In practical effect, the state's policy requires Trinity Lutheran to renounce its religious character in order to participate in an otherwise generally available public benefit program for which it is fully qualified. That condition, the court said, imposes a penalty on the free exercise of religion that must be subjected to the most rigorous scrutiny. Missouri's sole justification for excluding Trinity Lutheran from the playground grant program was to avoid raising Establishment Clause concerns. That did not suffice. The court held that excluding the church from the program violates the Free Exercise Clause. Justice Gorsuch joined nearly all of the Chief's majority opinion, but he wrote separately to announce two modest qualifications. The first was a concern that the court left open the possibility that a useful distinction might be drawn between laws that discriminate on the basis of religious status and religious use. Justice Gorsuch had some doubts about the stability of such a line. To illustrate, he offered a few examples. Does a religious man say grace before dinner, or does a man begin his meal in a religious manner? Is it a religious group that builds the playground, or did a group build the playground so that it might be used to advance a religious mission? The doctrinal point is not hard to grasp, but it had caused some difficulty for the court in past cases. Justice Gorsuch explained that the First Amendment guarantees the free exercise of religion, not just the right to inward belief or status. What this means, among other things, is that the government may not force people to choose between participation in a public program and their right to free exercise of religion. Justice Gorsuch couldn't see why it should matter whether we describe the public benefit, say, as closed to Lutherans, status, or closed to people who do Lutheran things, use. He said it is free exercise either way. His second point of departure was related, but it struck some observers as gratuitous. The Chief Justice had included a footnote in the majority opinion that might be understood as an effort to limit the scope of the court's holding. The troublesome footnote number 3 reads as follows: "This case involves express discrimination based on religious identity with respect to playground resurfacing. We do not address religious uses of funding or other forms of discrimination." Both statements are literally true, but Justice Gorsuch found himself unable to join the footnoted observation, and he went out of his way to say so. What are we to make of this skirmish over a footnote? We have no way of knowing if it signals a broader or deeper debate among the justices. All we have to go on is what Justice Gorsuch said on the printed page, and his explanation begins with a statement of the obvious. He acknowledged that, of course, the footnote is entirely correct. But he said he was worried that some might mistakenly read it to suggest that only playground resurfacing cases, or only those with some association with children's safety or health, or perhaps some other social good we find sufficiently worthy, are governed by the legal rules recounted in and faithfully applied by the court's opinion. His concern was evidently strong enough that he was moved to state for the record what any law-trained reader would already know. The free exercise principles that were decisive in the case were of general, not specific application, footnote 3 notwithstanding. Apparently, he thought it was important enough to make that point explicit, so he declined to join the footnote, and he closed his concurrence with this: "The general principles here do not permit discrimination against religious exercise, whether on the playground or anywhere else." Fair enough. More proof of Justice Gorsuch's formalist and textualist commitments can be found in his other separate writings from his first few weeks on the job, and also in his first few offerings so far this term. But I think that's enough food for thought for today, and a nice reception awaits us. So I will close this afternoon with a lighter moment from one of Justice Gorsuch's first oral arguments. And here I return to that point I made earlier about geographic diversity. The case was BNSF Railway versus Terrell, and it concerned personal jurisdiction in Montana over a railway that carried goods through the state but had no other presence there. The Chief Justice asked the plaintiff's lawyer about the limits of her argument. She responded that the rule need not extend beyond railroads. The Chief was not convinced that this line would hold. Here's the exchange. Chief Justice Roberts: "So trucking companies, they carry a lot of goods too. They're going to take, I-95 across Montana? Not 95, 90. Justice Gorsuch: I-80 across Montana." Chief Justice Roberts: "There you go. It's that geographical diversity. So I-80 across Montana, that's the route they're going to take. They're going to, just like the railroad is, going to follow the railroad tracks." Justice Gorsuch: "Maybe it is I-90. Then, a few minutes later, Justice Gorsuch: "And counsel, I must apologize. It's 90 across Montana, 80 across Wyoming. I'm very sorry, Mr. Chief Justice." Chief Justice Roberts: "Didn't I say 90? Thank you very much for your kind attention this afternoon.
We have a little bit of time for some questions, and I will steal the moderator's prerogative to ask the first one. It was often said that Justice Scalia, when he wrote, was not writing for his colleagues, was not writing for lawyers, was not writing for lower court judges, but was writing for law students. And he made public remarks suggesting that that's why he spent the time he did on the dissents and so on. He was trying to influence the law. Either from oral arguments or his opinions thus far, do you have any thoughts about who Justice Gorsuch thinks his audience is in terms of what parts of the legal community he's trying to reach?
I think he's writing for everybody, and that would include the general public and other stakeholders in the legal system. That's why I spent the time that I did in the prepared remarks on his first opinion for the court, because it's obviously directed first to the parties and to the lower courts. the users of the court's, the direct users of the court's opinion. But I think it's also directed, and some of his separate writings are as well, at members of the political community, people who write laws, and members of the regulated community, people who have to abide by those laws and navigate their way through densely written statutes. I think he's going out of his way to make his opinions, and he did this as a 10th Circuit judge as well, to make his opinions accessible to the general public and the regulated public, not just to what Justice Scalia used to call the law-trained elite.
We have questions. There is a microphone, so please wait for the microphone to go around. Questions for Judge Dissents? I have a whole bunch more, rather than your question.
Don't ask me about highways out west. I haven't.
I-80 is just a little south. Wait for them.
In the Hansen decision, he doesn't say that the plaintiff's argument on text was wrong. He just has, there's another way to view it. And the reason he chooses the one he does is not explained. And so it seems to me the textualist approach does not answer the question. And the other approach is the old legal process approach, which is to view the courts as working with Congress or the legislature to try to make a statute work. The Congress can always change if they don't like the result. So the court should not, I don't think, be so reluctant to try to make sense out of a statute which maybe is as a, who wrote this thing?
Well, that's a very good articulation of the opposing interpretive method, which Justice Gorsuch clearly doesn't subscribe to. He's a textualist and believes it's not the court's role to repair statutes or to try to guess what Congress would have done if it had confronted the interpretive challenge in the case. It's the court's role to read the statutes textually for what they say and mean to an ordinary reader, and in the Hansen case, that meant applying all the rules of grammar, not just some.
You spent a lot of time talking about Justice Gorsuch's writing, and I know that there's another judge on your court, Judge Posner, who's also very big on writing as an art and as a craft. Could you maybe draw a line between them or do some comparison between Judge Richard Posner and Justice Gorsuch?
Sure. My former colleague, Dick Posner, that's how he pronounces his name, was a brilliant judge and also just an incredibly gifted writer. His approach to judging is very different. He's the lion of the legal realists, and so rejected formalism, and I heard that over and over again in response to my own approach to cases. And I haven't counted, but I think Judge Posner, who was a wonderful, marvelous colleague during the time we served together, was the judge that I dissented or concurred against most often to separate myself from legal realism, which I am not a subscriber to. He has a very expansive expansive view of the role of the court and the role of judges, which is to achieve good outcomes and good consequences, and if that means departing well beyond the boundaries of the relevant text, so be it. And so he looks first for what is a sensible decision, and then repairs to the law to see if it fits, and if it doesn't, then he'll stick with the sensible decision as he sees it. which is not my own approach. And it's not Justice Gorsuch's either. He's a formalist, a textualist. He's going to read legal texts faithfully and as they would be publicly understood at the time of their promulgation. And that's his conception of the proper role of the judiciary, which is not to make the rules themselves, but to follow the rules that that lawmakers make. Yes.
So in defense, Professor Adler stole my questions. So this is one that's more off the top of my head, which is, I'm curious, in your reading, both of Justice Gorsuch, now on the High Court, but also as a circuit court judge, I know there was some concern or people were wary of having someone trained in natural law by John Finnis coming up into the High Court. And so I'm just curious, having read these opinions and comparing them to his circuit court opinions, I mean, are we seeing the John Finnis Neil Gorsuch? Are we seeing the Byron White Neil Gorsuch? Or are we just seeing Neil Gorsuch?
We don't know yet. Time will tell. I know he has obviously a well-grounded he's well-grounded in legal philosophy and in moral philosophy from his time as a Marshall scholar, and he has written widely as a scholar of natural law. And I wouldn't be surprised if that influenced his background understanding of the provisions that are enshrined in our Bill of Rights, which are stated at a very broad level of generality. But to get more specific than that, I think it's just too early to tell. But I wouldn't be surprised if he read those constitutional guarantees against a backdrop of natural rights jurisprudence, which was understood at the time of the framing to be the background set of principles that the framers were operating with in the common law system. The common law is full of natural rights jurisprudence, and that's the tradition in which our framers were writing when they wrote the Constitution. And that was obviously carried forward into our legal systems here.
So I know you said you wouldn't offer predictions, but you noted that Justice Gorsuch has gained notoriety for being very aggressive in some oral arguments, but there have been two cases thus far this term in which he was entirely silent. One, which is of particular importance here, the Husted case involving procedures for removing individuals from the voter rolls in the state of Ohio, and then the Janus case, where it is widely believed he's the deciding vote because the court split 4-4 on the identical issue. Obviously can't predict those cases, but should we read anything into those cases being the cases in which he didn't ask questions, or is there just nothing we can read from that?
Yeah, I don't know. It's really hard to make predictions based on oral argument. Some justices, and I know this not only from my own experience as a Seventh Circuit judge, but from my experience as a state Supreme Court justice in Wisconsin, court of last resort, every case is high stakes, high consequences. And some of my colleagues just would make it a practice of playing devil's advocate from the bench, and in ways that seemed very counterintuitive. And the lawyer would immediately sort of let his guard down and think, oh, I'm winning this one. And nothing could be further from the truth once we got into the conference room. I think it's just really hard to predict based on the questions that are asked at oral argument. Sometimes judges show their cards and sometimes they don't. So.
Other questions? No. Yeah.
So I'm not a lawyer. I'm a healthcare writer, but I have a minor in physical geography. And you had, and you had mentioned him coming from flyover country. I don't know how many people in this room have read The 9 Nations of North America, but it's a real insightful book about the societal differences that separate the 9 nations of North America. And I'm wondering how that might influence a judge that living in that particular bubble.
Mhm. Yeah, and bubble is the term that's being used to describe it now by some commentators. So it's interesting that you would use that spontaneously. I think this idea is being used to try to explain some of our political polarization now. I don't know if it does or not, but I'm not a political scientist or a political philosopher. But to your question about whether the experiences that a judge brings to the bench, including where the judge was raised, where the judge has practiced law and has been a judge previously, affect judicial decision-making, I think it probably does, to the extent that it makes judges more alert to the factual context in which the cases arise, and the results of that might attend systemically to a decision one way or the other. I think it's largely the case that judges are successful in putting aside substantive biases that might creep in based on past experiences. And I'm alluding here to the debate that arose in Justice Sotomayor's confirmation hearing about the Wise Latina speech that she had given. And I think it was important to read all the way through that speech. Something that got lost in the confirmation hearing is that she had a passage at the end of the speech where she talked about the imperative of judges setting aside their biases and deciding the cases that come to them based on the facts and the law. And her point was the one that I just made, that background experiences are not decisive in the case, nor should they be, but they do make judges more aware and alert to the consequence, the context in which the facts are developed and the facts are felt on the ground in the case and come to the court. We don't decide abstract legal issues. We decide real legal controversies with real people, and real consequences for not only the litigants, but broader segments of our society. And so those differing background experiences on a collegial court are extremely valuable. I have found them to be in my own court where I sit now and where I sat at the state Supreme Court. I was the Milwaukee justice on the court. The other judges or justices were from other parts of the state.
Give my former colleague one more question, and then we will wrap up.
You brought up the problem or issue of geographical diversity, but what about the fact that 6 of the justices went to Harvard Law School, and I think 6 or 7 are 6 of them are Catholic. Is that? Do you see that as a problem at all?
It's a good law school.
I went there too.
If I could have gotten in, I maybe would have gone there. No. I know there's a lot of attention being paid to the lack of diversity in a number of respects to the current Supreme Court. There's no politicians or people who were not Ivy League elites, essentially, is the argument. And I think there is something to be said from diversity of experience, diversity of legal education, diversity of geography, but I don't think that should be the decisive factor in picking justices. What's really most important is interpretive philosophy. That's what should be front and center in deciding who should serve on the court.
And what about judges with state court experience? There aren't any on the current court, don't
there are not.
Well, anyway, please join me in thanking Judge Sykes again. Super quick housekeeping announcements. Tomorrow, in the same room, there's a lecture by Professor Rebecca Tushnet of Harvard.